Judicial Academy. My name is Zamyan Chotanpatia.
So I'm Jablin Sherpa. I'm the CGM at Goutam and also the senior civil judge.
Good morning, sir. I am Jivan Khadka, District and Session Judge, Gazing District. Good morning, sir. I am L.G. Sherpa, Principal District and Session Judge.
I am Jagat Rai, District and Session Judge, Nancy.
Good morning, sir. My name is Rohini Rai. I am posted as CGM.
Good morning, sir. I'm Urvashi Pradhan and CGM Pakyong.
Good morning, sir. My name is Joanna Thapa and I'm the Senior Session Judge Story.
Good morning, sir. My name is Mahima A.R. Rai. I am posted as Civil Judge cum Judicial Magistrate from the Subdivision.
Good morning, sir. I am Nairitya Sharma. I am posted as Civil Judge cum Judicial Magistrate, Gangtok.
Good morning, sir.
My name is Sarvishta Siddhir. I'm a trainee judge and currently I'm posted at Goutam subdivision.
Good morning, sir. My name is Isha Pradhan and I am a trainee judicial officer.
Good morning, sir. My name is Ashita Pradhan. I'm a trainee judicial officer currently posted at Sore.
Good morning, sir. My name is Ashna Rohani and I am currently posted at Gazing and I am a trainee civil judge cum Judicial Magistrate.
Good morning, sir. My name is Aditya Subha. I am currently posted at Goutam as a civil judge cum Judicial Magistrate and I am also currently under training.
Good morning, sir. My name is Aishwarya Rajarai. I am also a trainee judge and I am posted as a civil judge cum Judicial Magistrate, Nancy.
Good morning, sir. My name is Devkumar Chetri. I am also a trainee judicial officer currently posted at Pakyong.
Namaste, sir. So my name is Ashwin Upredi. I am a trainee judicial officer.
Good morning to you all. Just I am not giving you any lecture to you. Just I want to share my experience with you. Because I served with Bengal Judiciary since 1980. Prior to that, I served as an advocate for 5 years prior. Therefore, I want to share my experience with you. If you think you want to ask any question, you are at liberty to put any question to me. First step. What are the basic principles of criminal law in India? You can note it. Can anyone say what is the basic principle of criminal law in India? Anyone? Because we are ready, just we are not giving, I am not giving you any lecture. It's the interactive sessions. Therefore, you may ask question to me and I also ask question to you.
So the accused is always presumed to be innocent until proven guilty beyond all reasonable doubt.
Presumption of innocence, we find it from our Constitution, Article 21. Next, burden of proof lies on the prosecution. Third, proof beyond reasonable doubt. Fourth, no crime without law. Fifth, no double jeopardy. Sixth, mens rea, that is guilty mind. Seventh, actus reus, that means guilty act. Eighth, principle of legality. Law must be clear, specific, not vague. Ninth, right against self-incrimination. 10th, right to fair trial. It's enshrined in our Constitution, Article 21. Equality before law. 11th. 12th, due process. Liberty can be curtailed except due process. No liberty can be curtailed, cannot be curtailed without due process. 13th, restorative justice. And 14th is punishment. These are the 14th point in criminal law. But the objective of criminal law? Objective of criminal law is protection of the society from the dangerous individuals and antisocial behavior. First. Second, creates a legal framework to prevent and to punish the offender. Third, provide justice to the victim. Fourth, establish rule of law. Fifth, ensure public order and authority are respected. These are the object. Now, let me evolution of criminal justice. On this point, if you have you want to ask any question, you may ask. I can explain and clear it. Next, we come. What are the basic principles of civil law? Can you say what are the basic principles of civil law?
Preponderance of probability.
Where there is a right, there is a remedy.
Yes. Next. Civil law, what we said, that is correct. Civil laws are remedial in nature. It provides remedy. Its aim to resolve dispute by granting specific relief, compensation, damage and injunctions. Second, based on recognition and enforcement of the private rights, corresponding duties. Third, burden of proof. Standard is preponderance of probability. Fourth, natural justice and equity. Fifth, where there is a right, there is a remedy. Sixth, matters finally decided by a competent court, it cannot be relitigated between the same parties. That is the principle of res judicata. Limitation. Delayed claim may be barred by law. And vicarious liability. And basic principle of the Evidence Act. What are the basic principles of Evidence Act?
Facts need to be proven.
Yes. Anything else?
Best evidence.
First, evaluation of the evidence in judicial proceeding. Authenticity, veracity and reliability. First thing. Second thing, evidence must be relevant and admissible. Third, hearsay evidence is not admissible, but there is exceptions. What are the exceptions of hearsay evidence, admissible in evidence?
Res justi.
Yes?
Res justi.
Then, anything else?
Dying.
Yes, dying declaration. Presumption of fact in issue. Fifth, burden of proof. Sixth, best evidence rules. Seventh, judicial notice. Eighth, admission and confession. Oral, documentary and circumstantial. These are all principles of the Evidence Act. Stages of criminal law. Can you anyone define attempt? What is attempt?
Try to
take some step towards performing after preparation.
a step towards preparation.
I am giving one example. Suppose a person intends to commit suicide. He went to a bazaar, purchased a rope, that is preparation. First intention that I will commit suicide. Second, purchase of rope, preparation. He he came to a lonely place, that is also preparation. He tied the knot in a branch of a tree, that is also preparation. He make a noose, that is also preparation. He put it into his neck, throat, that is also preparation. Thereafter he jumped from that branch, but his weight cannot carry, branch cannot carry his weight. It has broken and he fell down. Then that is attempt. The penultimate act he has done, the penultimate act of the offence. For some unknown reason that is not taken, that has not been taken place, that is, in such case, that is attempt. For that reason, concept of crime is first intention, then preparation, thereafter attempt, and last commission. If any question from anyone?
So in relation, we have had many cases in India where the political leaders and personalities are starving to death while they are protesting against issues of the government. So in those cases, how is this attempt to suicide applicable? Before we had in Manipur also, Sharmila was there, similar cases.
At first, attempt to suicide after coming to BNS, that has been abolished. I have stated only that way for giving an example of attempt. It can be, you can explain it in other ways. If a person want to commit indecent assault upon the heroine of Bombay, then he purchased a ticket from here and had been to the Bombay. That is preparation. He jumped upon, he scaled the wall. That is also attempt. That is also preparation. Thereafter, what things he entered into his room, but at that time he was not inside. She was not inside the room. That was the attempt. A person for the commission of offence, what is to be done, he has done everything. For some unknown reason, unforeseen reason, that has not been completed. In such case, that is attempt. Ask him to give you a hard copy to you. Okay.
Thank you so much.
This is one of the important things. Can you say what is informed consent? Can anyone give an example of informed consent?
Before surgery, arrest.
Informed consent.
During the time of arrest.
So what about before surgery, when the medical practitioner says this?
What is written here?
Consent given after understanding all the consequences of
Individual must fully understand what they are agreeing to, including potential risks and benefits, such as you are a patient, and when you are signing on the risk bond, you may die or you may not die. If operation is successful, you can. That is informed consent. Consent must be freely given. It is revisable. this is one of the latest concept, informed consent. Informed consent, when you are signing on the risk bond, that is informed consent. You know, this may happen.
In skydiving and bungee jumping, when we give waiver form,
Yes, that is informed consent. Consent must be given without pressure, manipulation, coercion. It's very genuine and willingness. When, as a district and session judge, when you deal with the rape case, then this consent will play a havoc but important role. Any question from you?
So, in criminal matter, while dealing this consent term, we have to seek the source, like Contract Act 1872. So, can you highlight from which source this consent has come in this particular nomenclature, and how to satisfy as a judge? Because we have to see the root from where this particular term has come, and satisfy ourselves with reading the statutory provision given there. So, can you highlight from which source this particular consent has come in the criminal jurisprudence?
Please repeat your question again.
So, my question is, now, the moment we see consent in Contract Act, that is a specific provision. And that deals with the civil matter basically. But in criminal matter, the moment we trace out, try to understand what is
consent. I got your point.
Yes.
In our legal arena,
yes,
mother of all laws is contract. Mother of all laws is contract. Even if everything depends upon contract. So all are, the Contract Act is all pervasive. In such case, only the subtle thing is whether the consent even same, whether it was obtained by practicing fraud or not, whether it obtained by coercion or not, whether it obtained by threat or not. This is to be judged. Whether the consent was given free consent or not. That apart, another thing is whether the consent is consent of a minor is no consent. Consent of a minor is no consent, that is given in Contract Act, but it is applicable to Indian Penal Code also.
You mean to say the same consent now defined in Contract Act 1872 is also applicable in criminal jurisprudence?
Jurisprudence. Same thing. Consent. You have to, when you are giving consent, you know the consequence and result of that very act. You are giving consent to do anything, you know, fully know the result and consequence of that very act.
For example, sir, the counsel who is appearing on behalf of the accused, the accused will gives consent to appear. The moment a counsel submits before the court, that can be taken into consideration as consent given by the accused. So now ultimately at the end of the trial, you will be convicted or acquitted. So if conviction is there, then he cannot challenge before the higher forum saying that no, I have not given this consent. So this particular consent given in criminal case, civil case, you mean to say derived from the same term, same statutory provision Contract Act 1872?
This is a good question. First of all, consent, what is the role of an advocate in a criminal or civil case? In a civil or criminal case, in a court, advocate is assisting the court not the accused, not the litigant. For that reason, he is also called as an officer of the court. He is duty bound to present the case of the his client in a truthful manner. It is not the duty to suppress anything, first of all. Thereafter, consent in such, therefore, Indian our CRPC provides section 330. Everything was done in presence of the accused. In spite of that, you are putting the questions to the accused directly, not through lawyer, because he has to know it. He has to give an answer. He has to give an answer. Therefore, consent given against a person, you have to see that was freely given or not. Freely given or not. The standard of proof is different. In criminal case, beyond reasonable doubt. In civil case, preponderance of probability. In civil case, a consent given by the lawyer that can be acted upon. But in criminal case, consent given by the lawyer that cannot be acted upon. Moreover, I will cover that very matter also when I deal with the revision and appeal. Prior to that, I am saying, you lawyer give consent and you punished him or convicted him. In spite of that consent, that can be challenged. If it was, that very consent was given by the advocate by practicing fraud, on the ground of fraud, that can be challenged. A lawyer stated that it was very often it was happened in Calcutta, Sialda and Alipur. Yes, lawyer stated the irrational driving and negligent driving cases that please you plead guilty, you will give only fine. Thereafter he pleads guilty and he was convicted. So says that lawyer told me, sir, I will not be convicted, I will only pay fine. So therefore that very consent has been obtained by practicing fraud, by manipulation. Not it was free consent. Therefore it is the duty of the court to make him know that if you pleads guilty, then you have to you have to suffer sentence also, not only fine. So therefore, in such case also, that can be challenged. That can be challenged on the ground of fraud. Another thing is nature of act. Nature of act. Lidecker versus Rex. That is a case of Privy Council. In that case, it's a very important case. In that case, a person, there was a called girl. He met with the Lidecker. Lidecker told him, he said that if you give me such and such pound, then we can intubate him. Thereafter, Lidecker intimated with that very girl, but as per promised, he did not pay. That very girl went to the court and said that he committed rape, my consent obtained by practicing fraud. He said he will give me such and such pound, but he had not yet given. Thereafter, this case had gone to Privy Council also. In Privy Council stated that the consent, you are giving consent of the physical intimacy, or the object was physical intimacy. Therefore, it is not, you may claim damage, but it is not a not comes within the purview of the offence, because you know the nature of the act to which you are giving consent. There is the subtle difference. It is only for the executive magistrates and the IPS officers. It is not for you. For judicial magistrate, this is one of the important. Unclaimed property. Sometimes any person, litigant, lawyers claim unclaimed property, you put application to you, But it is not your duty as per CRPC or criminal law. It is the duty of the executive magistrate of the criminal law, criminal division. In criminal law, justice requires not only fair trials but also mechanism to correct judicial errors. One such mechanism is criminal division, a special power vested to higher courts to ensure the lower courts to have acted within their authority in according to law. First of all, it is to be remembered that criminal division is not an appeal. It is a supervisory jurisdiction of higher courts to prevent miscarriage of justice. An appeal can be preferred on completion of the trial unless statute provides any special authority. In supervisory capacity, higher court deals with the appeal, reference and revision. Appeal is after conclusion of the trial. A reference when sessions court is not fully satisfied about the correctness and legality and constitutionality of the decision. The two contradictory decisions, it refers to the matter to the higher court for opinion and guidance. That is reference and revision during pendency of the proceeding. Then what is appeal? Judicial magistrate. Appeal, when appeal starts? Any judicial magistrate?
After judgment.
No, I am judicial magistrate. I am asking judicial magistrate. It is not possible for you. And after conclusion of the trial appeal, during pendency of the proceeding, that is revision. A reference is when sessions court is not fully satisfied about the correctness and legality of the or constitutionality of the decision or two contradictory decisions, it refers the matter to the High Court, its opinion or guidance for final decision. That is reference. Who can file revision? Accused can file, complainant can file, and victim can file revision. Limitation of revisional power. What are the limitations on revisional power? This is question for you. No, bolun, very. This cannot be challenged in revision. Where do you find this? Find out the section 397(2).
Yes. Start 397(2) to 401. So this, my question is, sir, what is the difference of reference in criminal case or civil case? Just now you have segregated especially just before.
Reference in both the in civil and criminal case, the principle is same.
Principle is same.
principal, such as you are getting two lawyer submitted on decision, and you know that decision is just contradictory of same bench, which has to be followed. Then you can refer it.
No, that can be done by the High Court only.
No, that can be, if Supreme Court does it, that can be referred to the
suppose if there is a conflicting decision of the Supreme Court, then it has to be referred to the Supreme Court only. Because how High Court can interpret the judgment of the Supreme Court, conflicting decision of the Supreme Court.
In case of Supreme Court, that is the latest decision will prevail.
Yeah.
In case of Supreme Court, that is latest decision will prevail. In case of High Court, as a session judge, you can act upon the latest decision or you may defy it. It is the wise decision to defy it. Which one has to be obeyed?
If there is no Supreme Court judgment to interpret that particular conflicting judgment only, in that particular circumstances, yes. And these are only the parameter where the court can look into for making reference.
Pardon?
These are the only grounds to understand the nomenclature of the reference in civil and criminal.
No. If there is any question against the Constitution, any decision against the Constitution,
or the virus,
then you can refer it. You cannot declare the law. You cannot declare that very judgment of the High Court.
No, at the time of, sorry.
But you can refer it to the High Court that it is against the principle of the Constitution. You can refer it.
So, what is the procedure when making reference? Should court frame the law point, or should on and on simply now writing one line saying that there is conflict of decision? What are the procedure for making reference to High Forum?
Then you have to state it that first of all, this decision stated so, this decision stated so. Then the ratio comes from these two decisions is conflicting. Therefore, let me know which one is the correct one, which one is the legal, which decision is supported by the Constitution.
No, the High Court will say, do you first take the decision.
This is not the purview, because CRPC and BNSS given ample power to defer it to you. I cannot decide it. You cannot decide a decision of two same bench, that is single bench. Decision of single bench. Which one you have to follow? Which one you have to follow? If against single bench there is a division bench, there is no problem. Against division bench there is a decision of Supreme Court, there is no problem. But only there is a decision of two, such as
two bench,
that is
single bench,
two bench,
two double bench.
There is a good such type of question arises in a case. That is a interim maintenance under section 125. One High Court just stated that it is the interlocutory order. Another High Court just stated that it is not an interlocutory order, it is a final in nature. Then which you have to follow? Interlocutory maintenance order is interlocutory order. It is not another single bench stated that it is not an interlocutory order.
It is sub silentio, without taking consideration of the formal order passed by the same High Court. The subsequent bench decided on the same issue.
It was the duty of the judiciary bench to defer that decision and give decisions.
Yes.
If that is not done, then what you have to do? So, husband की तरफ से एक तो डिसीजन आपको साइड किए हुआ है कि ये इंटरलोक्यूटरी ऑर्डर रिविजन विल नॉट बी मेंटेनेबल, एंड वाइफ की तरफ से आपको साइड किए हैं इट इज नॉट इंटरलोक्यूटरी ऑर्डर, एंड व्हाट यू हैव टू डू? Both are same single bench, same high court.
So under CPC 113, it states that while making a reference, the judge has to give his opinion also.
Yes. You have to give the opinion.
Opinion means that is the which is to be followed. This is the, because your opinion is one is against the constitution, against this order. That is the opinion. Opinion means this should be followed or not. The opinion means this High Court stated it is interlocutory order. This same bench stated, same strength of bench stated that it is not interlocutory order. And fact of the case is such. In such circumstances, which is to be followed. That is the opinion.
We cannot give our own opinion. This is to be followed.
No. Then there is no.
This is supposed to be followed in such.
The judicial officer cannot sit over the judgment of the higher court.
Then you have to. If that be the so, then you give first decision. First decision. No, bypassing that very decision. Reference you decide. No, that is a thing. In criminal case, only binding is ratio is the binding. Because in fact, in criminal case, ratio comes from the fact.
Obiter dicta is sometimes binding.
Obiter dicta is binding. Obiter dicta of Supreme Court is binding.
Yes.
Obiter dicta is High Court is not binding. Obiter dicta perimeteria is not binding.
Not binding to sovereign court. High Court obiter dicta.
High Court's obiter dicta is not binding
to sovereign court.
Sovereign court. You can explain. It is not not. But obiter dicta of the Supreme Court is binding. Obiter dicta of the Supreme Court is binding. But as a judicial officer, what we have to do? We don't take any risks. We don't take any risks.
No, we'll be set inside.
We don't take any risks. If you after when you have to descend from the, you have to state that it is obiter dicta, then you have to write so many things. You have another cases, lots of cases. Then one case will cover, take all the time, consume all the time.
Yes, sir.
All the time. ये एक तो बात है, एक तो बंगाल में एक तो बात है ये
Bengali.
हाँ.
There is a saying in Bengali.
हाँ Bengali.
Bengali तो बोलते पारे यार.
आइन ব্যবসা তো আপনাকে আইনটাও বুঝতে হবে ব্যবসাটাও বুঝতে হবে তো এখানে শুধুমাত্র জজেটি করতে গেলে পরে জজ হয়েছি বলেও বুঝতে হবে না হাইকোর্টের কি হতে পারে সেটাও বুঝতে হবে এটাও বুঝতে হবে তো academic thing is another thing and ওইখানে গিয়ে ডিল করাটা another thing.
এটা ব্রিটিশ পলিসি আপনাকে
সেই হচ্ছে ব্যাপার কারণ সবচেয়ে বড় ব্যাপারটা হচ্ছে কি যে ধরুন আপনি 302 এও বেল দিতে পারেন বেল দেওয়ার কোনো বাধা নেই দিতে পারেন ওম্যান সি তার এজেন্ট দিতে পারেন ইন স্পাইট অফ দ্যাট কেউ রিস্ক দিতে চায় এটা তো সোজা বলে why we invite Trump because you have to before you sleep you have to go long way.
Yes.
In revision, court cannot deappreciate the evidence. It may lead to reversal of the decision, correct the jurisdiction or procedural errors. In this way, this court exercises the revisional power. This is the practical importance of the revision. I will give you a hard copy of these decisions. These are the reviews. It is a discretionary power, and its scope is very narrow. Amarnath versus State of Maharashtra. AIR 1977 Supreme Court 2185. Second, revision maintainable only in respect of final and intermediate orders. Girish Kumar Suneja versus CBI. AR 2017 Supreme Court 3620. Powers of High Court cannot be exercised in respect of interlocutory order. Girish Kumar Suneja versus CBI. इसको प्रिंट आउट लेकर आपको दे दे बहुत सारी है, ये 60 पेजेस है। अगर चाहे तो हम सबको भी भेज दे सकते हैं। हाँ, आप सबको भी भेज दीजिएगा। It has not been defined in CRPC or any other law books. Law books means statute. The background of the appeal in ancient and medieval origin. In ancient and medieval origin, it was first. It has been found in Rome. The provocatio ad populum. The Roman citizen has the right to appeal against the death sentence and severe punishment to the populum assembly. Emperor was the authority. Only citizen has the right, non-citizen did not. Appeals were discretionary, not automatic.
There is no provision for.
In ancient Rome, no, I am saying before Christ. It's the origin. Where from the appeal came. ancient and medieval origin of the medieval Europe, feudal court had no formal appeal system. Writs of error in royal courts allowed review of mistakes, but only for the nobles and clergy. Catholic Church developed the canonical appeals to the Pope. English common law, I have written here, the Court of King's Bench review the lower court's decision, no appeal on facts, only on law, required royal permission. In 19th century, British birth of modern criminal appeal. England Criminal Appeal Act 1907, 1907 criminal appeal, it was statute. Created the Court of Criminal Appeal. Question of law and facts are dealt with. The question of sentence also considered in USA. Federal Court, Judiciary Act 1789 allowed appeal, but scope was very limited. Twentieth century USA constitutionalized the appeal. England established Court of Appeal in Criminal Division. History of criminal appeals gradually shifted from royal discretion to legal right, following the rule of law, wrongful conviction, human rights standard, and fair trial. Criminal appeal in Hindu law and jurisprudence. Hindu law, rooted in the Indian legal tradition, primarily derived from the Dharma Shastra. As per Hindu law, criminal appeal was not formal. Due process was followed in structured hierarchical review. Appeal was discretionary, initiated by aggrieved party or petitioner, focused on errors in procedure, evidence, interpretation of 8,000 Shastric principle. There was no professional lawyer, self-representation was promoted, or elderly person given assistance. Manusmriti, implying the appellate scrutiny to the avoid adharma. Jagopalko's Sriti allow the appeal in criminal cases. In case for manifest injustice, including excessive sentence. Village Assembly Court, Panchayat, local tribunals deals with petty cases. Order of the tribunal appeal may be preferred to district court. You find it reference from Narada Sriti. Mid-level offence, multi-judges court against such order, appeal may be preferred to the King's Court. Appeal may be presented orally or in writing, no automatic right of appeal required. It was called Vyavahar Dosh, legal flaw, evidential error, procedural lapses, excessive punishment, appeal to disposed of within 1 lunar month, preferably. Old Hindu law, in case 1 lunar month में appeal को dispose करना होता था. New evidence may not be taken. New evidence may be taken in sparring cases. No jury or adversarial system was followed. Absence of professional advocate, but keen friends or wise person may be allowed to present the case. Appeal prioritize prashchitya over retribution. Equality and dharma were followed in appeal. Kautilya in his book Arthashastra advised to counsel jurists for disposing the appeal. King has to follow the Rajdar. In Islamic law, Sharia has to be followed. There was no express provision of appeal in Islamic law, but emperor could pardon or revise the sentence against the order of Qazi in limited scale. Maybe appeal before the provincial Sadar, means chief religious judge. Meaning of appeal. I have already stated that appeal has not been defined. In spite of that, appeal means applying to higher court for reconsideration, re-evaluation of decision of lower court. It's a judicial re-examination of the case by higher authority. Appeal court can affirm, reverse, modify and remand the decisions. Appeal is a creature of statute. No one can claim it as a fundamental right. Appeal is a continuation of the original proceeding. Appeal allows an aggrieved party to approach superior court to challenge the legality, propriety and correctness of a judgment, sentence passed by the lower court. Who can file appeal? Accused person against the order of conviction or sentence. State government through public prosecutor against the acquittal or enhancement of the sentence. Complainant in case of complainant case with the lead, victim, legal representative, jail appeal. Both the appeal arises from the same judgment filed by the both parties. Separately, cross appeal be heard together and disposed of by a common judgment. You have got these things, which is cross appeal. Cross appeal be heard together and disposed of by a common judgment. Limitation period for filing an appeal. By a convicted person 30 days from the date of judgment, by state government 30 days, by a complainant 60 days. Delay may be contained under section 5 of the Limitation Act, if sufficient cause is shown. Power of the appellate court: dismiss the appeal if no merit, reverse the finding, acquit the accused or convict the accused on rehearing and can take evidence, alter the nature and extent of sentence, enhance the sentence, remand the case to lower court. Appeal, both a question of law and fact. Appeal court can reappreciate the evidence. No appeal in certain cases when accused pleads guilty and is convicted on such plea, except as to the extent or legality of the sentence. What you are stating. Probably you asked the question. No appeal in certain cases when accused pleads guilty is convicted on such plea, except as to the extent or legality of the sentence. or if it is passed under misconception of the law. गिल्टी प्लीट करने से भी अपील कर सकता है। नो 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 मान लीजिए एक केस में 2 साल का पनिशमेंट है, आप गिल्टी प्ली किए, हम 3 साल का कन्विक्शन दिए। ऐसे भी हुआ था जब हम मालदा में पोस्टेड था, एक मैजिस्ट्रेट ने लाइफ सेंटेंस दे दिए। हाँ, क्योंकि उस टाइम फूड एडल्ट्रेशन एक्ट में लाइफ सेंटेंस का प्रोविजन था। अभी भी कर सकता है ये मैजिस्ट्रेट लोग। 326 में कितना पनिशमेंट है दे सकते हैं, इसमें तो है मैजिस्ट्रेट केस है, हम लोग सेंटेंस दे दिए, कर सकते हैं।
Special Act has provision. Special Act has provision, and that particular provision is not guided by the CRPC.
IPC में 326 में तो है लाइफ इम्प्रिजनमेंट।
No, that Constitutional Court has to refer that matter to the High Court for confirming this passing the order.
In which court he will refer? Magistrate?
Usually magistrate to CGM.
The CGM has power to convict which year?
7 years.
7 years. Then there is a 326.
Yes, 326. Absolutely right.
Then is it vague life imprisonment?
Life imprisonment, if the prescribed punishment all given to the magistrate is beyond 7 years, then he or she has to refer.
In which court you will refer it? Is there any scope for reference? CRPC provides any reference? But if it is refers to CGM, then also he can convict a person only for 7 years. Yes, the fallacy is if 326 is tied with other section in a sessions tribal case, sessions cases, session judge can convict. In such case,
Road provision can't be. Because there is a provision on
because it is a magistrate tribal case, magistrate can give punishment only for the 3 years. In such case, the one magistrate can
up to 3 years.
3 years.
No, we are confining to the provision of CRPC. Like in Judicial Instrument Act, the magistrate can up to how much, up to what extent they can sentence so far the amount of fine is concerned. Beyond the parameter laid down in the CRPC.
No.
Special Act has to be
There is specific decision of Supreme Court. You can award compensation any amount, but you cannot sentence him more than that. If you want to know that, I can provide you that decision also.
So then,
Magistrate has power to 3 years and 5,000 rupees in earlier CRPC. Now it is changed. Then you have to give sentence. A magistrate can give sentence only that portion also. And the compensation, in such case, Supreme Court specifically stated that as there is a no limit for compensation, magistrate can award compensation any amount. If you punish him, he has to give punishment within the periphery of the CRPC. CGM can have 7.
CGM. If there is a problem for life imprisonment, then where the Constitutional Court will refer?
That if only charge framed only 326 by a magistrate, then the ultimate punishment is 7 years. If a charge is framed by the session judge with other sections, then it can be done.
Even if life this manner provision is there, but the concerned court can go to the extent.
So there is no provision for referring it to the certain court. Magistrate can refer it to the CJM for higher punishment, but it cannot go to
This can be
the.
sent to the higher court.
High court means magistrate's high court is CJM.
High court.
Magistrate cannot directly for the refer for the punishment. He cannot refer. The CRPC does not provide any such provision, any such section. The magistrate cannot act at his own will. He has to work under the provision of the periphery of the CRPC. CRPC provides him provides the section for to refer him to CJM.
From JM to CJM, it can be referred. No further.
If a magistrate can give a declaration of a divorce,